USC 102 basically says that if somebody else has created some prior art that is in existence anytime from right before you file the patent application to a year before you file the application, depending on where the prior art was created and how it was published, you can have your patent application rejected as not being the first to have invented this particular invention. Some common examples of prior art are issued patents, published patent applications, products for sale on the internet, articles that were written about a product, perhaps showing up at a trade show and displaying your product for sale more than a year before you file a patent application on it. So even an inventor's own disclosure, his or her own sale of the product, can count against them getting a patent later on. 35 USC 103, on the other hand, says that if you have an invention that is deemed by the USPTO to be a mere obvious improvement over somebody else's invention or some other prior art that's out there, then you can be denied a patent under 35 USC 103. So what is an obvious improvement? Well, that changes depending on the latest court decisions, the latest laws, and the latest So what is 35 USC 103 and why does the inventor have to be afraid of it? 35 USC says you can have a patent application rejected if your application is a mere obvious improvement over existing prior art. Prior art can be another patent, a published patent application, some sort of a published magazine article, book review,